The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
I'm sorry, Madam Chief, I didn't see you back there. We were just doing our
So, Mr. Chairman, does this violate separation of powers for her to come testify?
No, it does not. In fact, there's a statute. Okay. There's a statute that we passed probably before either of us were of age that says that judges of the Supreme Court are invited to come and talk to us about administration of justice and other matters too.
Good afternoon, Senator Klein, members of the committee, Juliana Rowe Committee staff. Before you is Senate Bill 5630. There are currently 64 part-time municipal court judges, some of which are elected positions. Those 64 judges serve approximately 80 cities. In cities with an appointment process, the judge is appointed to a 4-year term or confirmed by the council upon recommendation of the mayor. There are 31 full-time municipal court judges. Current law requires the election of municipal court judges when the judge is compensated for 35 hours or more per week. In cities where the judge works fewer hours, it is discretionary, whether the position is filled by election or appointment. This bill would change current law such that within 30 days after the effective date of the ordinance creating the municipal court, the mayor of each city or town must appoint a municipal judge or judges to serve until January 1st of the year following the next election. The legislative authority of a city or town has the power to confirm appointment of a municipal judge initially appointed. A person appointed as a municipal judge must be a citizen of the U.S., a resident of Washington State, and an attorney licensed to practice in Washington. The legislative authority of the city or town must by ordinance provide for the number of full and part-time judges to be elected. These elections are held at the same time as other city elections. Eligibility to serve as a municipal judge requires the person to be, again, a citizen of the U.S., a resident of the state, and either an attorney admitted to practice law in Washington or in cities or towns having a population of less than 5,000 people, a person who has taken and passed by January 3rd of 2003 the qualifying examination for a lay candidate for judicial officer. If there's a void or a lapse of an election in a city or town with a population of less than 10,000 people, filings for office are not reopened and the mayor must appoint a qualified person. The legislative authority of the city or town that has the power to confirm mayoral appointments has the authority to, has the power to confirm a municipal judge appointment. The terms for judges serving on the effective date of this act and municipal judges who are appointed to terms commencing on the 1st of January 2014 expire January 1st, 2014. Oh, terms commencing before, I'm sorry. Their successors' terms begin on that date and on January 1st of each 4th year thereafter.
Okay, thank you. I think we can stop there. I think members are familiar with the terms, having heard this bill earlier last year, and I think several years before that. Senator Harper, you want to say a few words about it?
I know the committee's heard the bill before, so I'll be very brief. As an attorney, I recognize the importance of having an independent judiciary to acknowledge that that we must make sure in every way that we can that justice be unbiased and fairly applied everywhere in this state. We need to maintain some consistency, I think, in particular among our courts of limited jurisdiction. And I don't view this in any way as a presumptive accusation that of anything other than an acknowledgement that we have separate branches of government for a reason. And I believe that there is wisdom in that effect. And I'm proud to be sponsoring the bill and very humbled and pleased to have our Chief Justice here to speak to it today.
Thank you. Before we get into statements, wisdom indeed. It's the wisdom of literally this country's founding fathers to keep the judiciary independent and separate at the federal level and at the state levels.
Are we all going to make third reading speeches before the justice
No, we're
starts?
not. But I just want to say there's more than just a little wisdom here. Okay, why don't we go then directly to the Chief Justice and other members. Just setting the stage for you.
Thank you. Thank you.
But we need a
Good afternoon.
mic.
I do want to extend my appreciation, of course, for the invitation, Senator Hargrove, to be here to speak to this issue. For the record, I am Barbara Madsen, the Chief Justice of the Washington Supreme Court, and I am here to speak on Senate Bill 5630. I want to also thank the sponsors of this bill, Senator Harper, Senator Flug, and Senator Cole Wells. I very much appreciate your willingness to bring this to the attention of the committee as well as to your colleagues. You already heard the bill. We have the election of judges at every level of court except our municipal court levels. And we firmly believe that the value of course, an independent, impartial judiciary will outweigh any of the detrimental side effects of having the election of judges, which means putting them on the ballot, along with every other elected official in the city or county. I know I don't have to remind you of this because you here serve a democracy, but one of the hallmarks of a democracy, of course, is the right to access to courts. And it's really the fact that a country has a democracy that means we need to have fair and impartial courts. In the past, of course, we've had any number of different models. Our founding fathers from England, of course, had judges who served at the pleasure of the crown. And when the crown died or when the crown was passed, then the judges were also they were also removed. So, based upon our current democracy, the rule of law requires that judges make some very unpopular decisions. And that is just a function of the system. One measure of a judge's unpopularity is that a court's decision often would not get a popular election. That is, a decision made by the court would never be made the law of the land because it would not be a popular point. And so that's one of the hallmarks of a judge, is to make those kinds of unpopular decisions for the community and for the people that we serve. I started off in a municipal court. I was an elected judge, but I want to share two things that happened to me early in my experience as a trial judge. The first was that the City of Seattle passed an ordinance outlawing panhandling. And in the first 6 months that I served, I had occasion to strike that down as being unconstitutional, as a violation of First Amendment rights to free speech and to free assembly. I had a call the day after I made that decision from the mayor's office, asking me why had I not called them at the mayor's office to warn them, or at least to talk about it before I did it. And that was as an elected judge. I can assure you that if I were an appointed judge and I was looking to have my contract renewed at the end of my term, I certainly would have felt differently than I did receiving that phone call. I was able to say to the person on the other end of that line, it would be extremely inappropriate for me to talk to you about my decisions before I made them, and maybe even after I made them. The second incident happened when the City of Seattle, or the King County built its new jail, and they were leasing space to the federal government and others in terms of needing jail space. And so I got a call from the director of the King County Jail wanting to meet with me. And it was really kind of a full court press to urge me, as the presiding judge of my court, to urge my colleagues not to use jail space because they needed it for other purposes. Now, if I was on a contract, I can assure you I would have reacted a little differently than because I was an elected judge. As an elected judge, I would take that into consideration, but I would certainly not feel that the renewal of my contract depended upon my decision with regard to that request. Now, that's 20 years ago when I was in the Seattle Municipal Court. Recent examples reveal that the very same things are happening to our municipal court judges today. We have an example that a city council resolution was passed in one of the cities requesting the judge to reduce jail commitments by 50% and to reduce the term of probation for offenders as, quote, prudent fiscal practice. This is a situation for a judge who's on a contract that is not going to be comfortable. And when judges make the wrong decision, they are not renewed in their contracts. We have another example of a municipal court judge having to seek a restraining order to prevent the city mayor, I believe it was, who wanted to bump his court clerk in favor of a clerk who worked in the mayor's office because of seniority. The judge had to go and get a restraining order. At the end of that judge's contract term, that judge was not renewed. So these are just a few examples of the kinds of things that happen today. They happened 20 years ago when I was a judge in the municipal court, and they will continue to happen. We're not asking for anything extraordinary here. All the judges in the state are elected. And the reason for that, as I said, is that a democracy requires judges to make unpopular decisions. We don't need the loyalties of our judges to be divided between the mayors and the city councils and the fiscal concerns that are raised by those members of the government. We need judges to be thinking about the people who appear in front of them and making sure that those people get a fair and impartial hearing, that the judges are not acting on behalf of the mayor or the city council. They are acting on behalf of the law and on their oath of office to fairly and impartially make decisions based on that law. So I'm asking for your support on this bill. It is one of the highest priorities for the Board for Judicial Administration, which is the governing body for the court system. So we have made this a centerpiece because it is one step forward toward bringing professionalism to the justice system in the state of Washington. Thank you for your attention.
I have a question.
Thank you, Madam Chief. If you don't mind answering a few questions.
I would be happy to.
Margot.
Nice face.
Remember, I'm a guest.
Yeah. Okay. Well, my concern isn't so much with the influence in that fashion, but we've had this discussion before, I think, about how do we deal with judges that are outside of the bounds of the law. What I mean is that they make decisions continually that are overturned and people have to appeal, et cetera. I don't see a process that allows judges at any level to be reprimanded for, consistently ruling wrong on a particular issue. For instance, you talked about the panhandling. If you would have ruled it was okay and then were overturned on appeal, and the next one that came in front of you, you ruled was okay, it was overturned on appeal, and you persisted in your position even though it was wrong, I don't see any way to deal with judges like that. And then when we have municipal judges in very small jurisdictions, which maybe there will be very little interest in running for, we can get people with maybe very interesting backgrounds and opinions that could have a huge impact on people's lives with every decision they make. Not the city and not how many people go into jail and that type of thing, but on individual, and there's no real way to remove them until the next election. And the legislature, when we've got fruitcakes here, which we all are, we are insulated from impacting the public, both by the corporate nature of our legislative work and by the judiciary, frankly, who can step in and say, no, that bill you passed is unconstitutional. So it can protect the public. But a judge has a direct impact on people, and I don't see any way to remove bad judges that, and I don't mean bad like committed a crime. I mean just over and over and over again, just disregard the law. Can you help me with that?
Mr. Chairman.
I am fully aware of the fact that we have a discipline commission, and it is, of course, constitutionally based. I have read many decisions from the Judicial Conduct Commission. I would say that, and not to impugn any of my colleagues, but we have more misconduct at the level of the municipal court than any other in terms of their lack of professionalism. And so I guess I would ask back to you, what do you do about judges who are appointed and who are unprofessional, but they do the bidding of their boss? That is to say, the person that they report to is the mayor. So I guess you're going to have in any system, you're going to have the potential for a bad judge or a bad legislator or representative of the public. But our Conduct Commission, in my view, has actually worked quite well. The question you posit has to do with making decisions. Ordinarily, one is not disciplined for making a decision.
That's my point.
On the other hand, I don't think we've ever had a conduct complaint that involved a judge who, in the face of precedent that he or she is sworn to uphold, has not done so. If that were the case, I don't want to offer an advisory opinion here, but
you want to send me on a search because I could probably bring you some.
Well, I would be interested to know what the Conduct Commission would do with a complaint about a judge who, in the face of precedent that he or she is sworn to follow, has refused to do it over and over and over again. Contrary, I've seen in municipal court settings where there were practices that are not authorized by law, but which assist in terms of the fiscal impact on the city of having a city court. Those practices have been routinely engaged in, even though there is no authority of law. And I've seen that far more often than I have seen
Well,
the
you're just
suggestion
telling
you
me,
made.
though, if that is the case, then those judges should have been removed by your Conduct Commission.
Well, if they were reported, and that's generally where I've seen the conduct being reported. Let me give you an example of this where...
If you know about it, it was reported.
No, what I'm saying is that when the conduct of judges is reported, we have disciplined the judges. In one instance, we disciplined the judge, and the city didn't much like us disciplining the judge. They were so fond of his practices because they were, indeed, they were assisting the city financially because he would, if you asked for if you pled not guilty with the same form, you would waive your right to a jury trial in the same form, because by pleading not guilty, you automatically had agreed not to have a jury trial. So this was a practice that was, it's illegal, it's unlawful, it violates the Constitution, violates constitutional rights of those individuals who signed those forms, and we disciplined the judge, and the city was quite annoyed with us for doing so, and I think actually would have kept him on as a judge after his discipline period, but the man chose to retire. So my experience is not your example. My experience is more the experience of having a judge who was beholden to the city legislative authority or the mayor who would prefer to keep his job or her job.
If you have any examples, this is a question, if you have any examples of where the Judicial Conduct Commission has reprimanded or done any discipline on a judge for something other than personal conduct, meaning being rude or harassing somebody or committing a crime or stealing money.
The example I just gave you.
If I would love to see that, please.
Okay, I'd be happy to give you that.
Okay, Senator Roach.
Thank you,
and then Senator Carroll.
Mr. Chairman. And I will be ending my statements with, can you help me with that, which is what Senator Hargrove did to put this in the area of a question. First of all, I would like to say that I believe Justice Sanders was hauled before the Judicial Conduct Commission for giving a 70-second or 50-second speech, and the punishment itself is what you end up paying for your own legal fees, etc. So I think the commission is kind of reverse sexist on a lot of things. They should be elected themselves. They are not, and they are a very liberal body and not so easy on conservative judges or justices. That having been said, one of the things that concerns me, and this is where I'll get to the what can you help me, how can you help me about that? I think in King County there are, correct me, 53 Superior Court judges.
That sounds right, but there's probably somebody who knows better.
53 or so Superior Court judges, and I remember when they were up for election that only 2 were ever challenged. There were only 2 that had at least 2 people running for the position, and when I investigated it, found out, in fact, that there were open seats. In other words, there's such a tight community among lawyers that they don't dare run against a sitting Superior Court judge, because in doing so, I guess the whole group would pack together, and anytime that attorney would go before any of the 52 or 53 judges, that they at least would think they wouldn't be treated so well. Otherwise, we'd see more contested races in Superior Court, at least the one I'm familiar with in King County. So can you help me with how we can actually benefit from the fact that we do have elected judges in this state, something that isn't occurring in many other states? They're appointed.
Mr. Chair.
But what is it that can actually make the system work?
Well, I guess
it doesn't work if there's no competition.
Well, I guess it depends on what you think the system should do. I'm sorry, should I not answer that question?
I'd love to hear an answer.
Well, I'm happy to.
Objection.
Oh.
No, I have a question or comment, but I'll wait.
Yeah, answer my question first and then go over there.
I think it depends upon what you think election of judges is intended to accomplish. In my view, the fact that a judge is not challenged, it's very much unlike your situation where you're running on a partisan ticket. You stand for the Republican message, or you stand for the Democratic message. And so people in your district want your voice because you represent them directly in this House. We don't, as judges, we don't represent anyone, and so if a judge is doing a good job, there is really no reason to remove them.
Nobody knows what kind of job they're doing. No one follows. So we used to have court watchers, and we don't. And because they're not making news unless it's some big, big case that comes before the press. And even then, I've noticed they hide the name of the judge. You don't get to see this. And so when the judge can't go out and campaign on issues, which they don't do, and when the press isn't covering it and the names aren't brought forward, we don't have competition, and our framers believed that we should be able to do that.
Well, if you remove the election, you'll have no opportunity for that.
Oh, I'm not. Listen, I support election of judges. I'm just telling you that there is a problem, a systemic problem within the system, because we are not seeing the what was intended, I believe, which is a little bit of vying for these positions, and so they tend to stay forever. Now, you get a guy like Gary Little, and he's the reason, as I recall, that we have a Judicial Conduct Commission. Fiddling with little boys, I think, was the deal, teenage boys.
Excuse me,
and,
Senator, before we get off the subject of the election of judges, we are going to, as you know, have a very full agenda today, and we're getting a little bit off the subject.
A little interesting, though.
Senator Carroll and then Senator Cole-Wells, and I'm going to ask that we stop questions at that point.
Well, thank you, Mr. Chair. Just a little reminder, this isn't a democracy, it's a republic. And I know you know that, but just, something I think that we need to keep in mind, that it's a republic. And, repeatedly we have people in here talking about separation of powers. But there's something, and when I look at the Constitution, which we both work with and under, I have to remind myself it has a structure, and there's a reason why they've taken the executive branch and broken it up into multiple pieces. They've got two bodies of the legislature, why we have, and in the case of even the judiciary, we have several parts. Unfortunately, we've lost our justice of the peace, but nevertheless, there is a reason for that, and it's to keep a concentration of power in any one place, to make so that no one part can make, hopefully, really terrible decisions, and they can't be countervened. So I'm just reminding everybody that this is something we need to look at, and why I have real reservations about putting everything in the judiciary under one single head and not having multiple parts. So, comments?
Yes, we have a non-unified court system, and so actually among all the states, we have probably the most responsive system of a judicial system in the country. That is to say, local decisions are made at the local level. I have no control, other than the bully pulpit, over judges at any level of court, including my own, I can assure you. And so,
welcome to the club.
I gathered this was probably true here too, but frankly, that is why we have election of judges, and that's why we have a non-unified court system, is to keep control at the local level. But you can go too far in local control. You give control of one branch to another, you have lost the value of the genius that I think was our constitutional construct. That is, three separate branches of government that provide checks and balances on one another. And if you subsume one branch into the other, I think you have lost the checks and balances that we founded this nation on.
Well, I guess it goes back to my concern about it a little ways back with Marbury versus Madsen and a few other things, but nevertheless.
Before my time,
mine too. But.
Okay, are we done then? Why don't we go to Senator Cole-Wells?
Thank you, Mr. Chair. Just a comment. I appreciate Senator Roach's point about non-competitiveness and perhaps too many races, but I really object to casting aspersions on individuals in terms of their motivations to not, or decisions to run or not run, and in effect an implied collusion on the part of groups. That really bothers me, and I don't think it's appropriate.
JC.
Well, now she's casting dispersions on me.
Okay. Okay, why don't we continue? Senator Wells, go ahead.
I finished. Thank you.
Okay. No further comments and questions. Thank you very much for. I appreciate your coming into the Lions Den.
Well, I've enjoyed it, and I would
You
actually.
might not accept the invitation next time, right?
Oh, no, I would in a heartbeat. This was a pleasure to be able to give you my point of view. So thank you for the time.
Thank you. Okay, testifying also in favor of the bill, I'm going to have a panel. I cannot accommodate everybody who's signed up for the panel, so we will then follow that with an equal time given to a panel of those against. Starting with those four, Judge Stephen Brown and Judge Stephen Warning, Judge Brown being of the District and Muni Court Judges, Judge Warning being of the Superior Court Judges Association.
In the interest of time, I will defer to Judge Brown.
Okay, thanks.
Also, in the interest of time, I'll be available for questions.
While you're up here, the panel against will be composed of Jim Haggerton of the City of Tukwila and Diane Suppler, I hope that I have that right, of the City of Sumner, and Candice Bock of the Association of Washington Cities. The prize for coming the longest distance comes to Judge Rebecca Baker. Is Judge Baker around? Hey, howdy. There you are. Okay. She's all the way from Colville. So, who'd like to start?
Start with Mr. Haake and then Judge Brown, and I'll just
Judge Brown, go right ahead.
Senator Klein, my name is Judge Haake, I'm sorry, my name is Doug Haake. I was, during 2008 and 2009, the appointed municipal court judge for the City of Bonney Lake. I am going to tell you about one incident that occurred while I was at the City of Bonney Lake, which I think may assist the committee. I had a DUI charge pending in front of me. It was a police chief from a local jurisdiction. We were pending motions. I went to a party of management from the City of Bonney Lake. This was around Christmas. During that party, the police chief, the mayor, and the city attorney all told me short stories about having been stopped by an officer for committing a traffic violation and having gotten a pass. That is, they did not get a citation. On the way home that evening, my wife looked at me and said, "Could you lose your job depending on how you rule in this case?" I don't recall answering her question, and I don't know that that's the reason that I was not reappointed. But I certainly did take those comments into consideration in making my determination in that case. Thank you. I would be happy to answer any questions.
Senator Roach.
Yes, since I represent Bonney Lake, who was the mayor at the time?
Neil Johnson.
Okay, thank you.
Okay. No further questions? Okay.
All right. My name is Stephen Brown. I'm a district judge in Grace Harbor County. I'm currently president of the District and Municipal Court Judges Association. And it's been our position as an association over the last several years that all judges should be elected, including all judges at the district and municipal court level. So that remains our position, although there are several members in our group who have opposing opinions, and we've taken those into account in our position, but it remains the same.
Okay.
So
you guys voted on it, and that's the vote. I have a question for you. District court judges, I would imagine, since they are elected, aren't going to be governed by this in any case.
Right.
It's only the municipal court judges. Are you aware of stories among them, or have other cases been brought to your attention in which judges have had this kind of question?
Yes, I am.
Okay, just checking. It's not. This is not some kind of an anomaly, then.
There's been at least several instances last year, but that was the cycle for the reappointment of municipal court judges. Mm-hmm. And that's when a lot of those issues became clear to the judges who were elected, and then there asking around saying, well, it looks like I'm done. And they gave various reasons why.
Gotcha. Okay. Further questions? Melanie, you're just here to answer questions. Are there any questions, Melanie? Hearing none, thank you very much. Appreciate it.
Thank you.
Okay, and going to the con side, could witnesses come up?
Thank you very much. My name is Candice Bock. I represent the Association of Washington Cities. As you heard, approximately 100 cities rely on part-time appointed judges. About 50 of those cities operate court less than 15 hours per month, and another 20 operate court less than 10 hours a month. We believe that municipal courts with part-time judges, appointed judges, fulfill an important piece of our criminal justice system, and they meet the needs of their community. With that said, I think we're all committed to the same goal, which is preserving the independence of our judges and their courts. We think that our cities do an excellent job of this. Cities operate courts not to generate revenue. In fact, they're money losers, but we do it to ensure access to justice for our communities. We understand some of the judicial branch's concerns. We'd be more than willing to work with them on additional training and identifying best practices for our cities and their courts. It's clear, though, from AOC's recent records request, which I've provided you a copy of, that the judiciary is more interested in finding things that we're doing wrong than helping us to do things right. And we think that it's a missed opportunity at this point. We'd really like to have a stronger partnership, especially when it comes to training and best practices. Trying to move quickly through some of my points. I apologize. We don't believe that there's any difference in the standards between elected and appointed judges. They are held to the same standards. They're all subject to the Board for Judicial Conduct. And in fact, between 2006 and 2008, there were 16 sustained actions. 13 of those were elected, 3 were appointed. That roughly is about the same percentage. But of those 13 elected, 6 were elected municipal court judges. So that's not exactly the most positive trend and doesn't necessarily speak to the fact that appointed judges are doing things wrong. In regards to elections and those resulting in better qualified candidates, Justice at Stake found that 76% of citizens believe that campaign contributions affect a judge's courtroom decision. And it's common for 25 to 33% of Washington voters just to skip the judicial candidates on their ballot. We took a look at the municipal court judges that ran in 2009, the last time they were up, and 80% ran unopposed. And the participation rate for voters dropped by about 20% as compared to their city council counterparts. So people just aren't as involved in judicial elections. It's harder for them to get information about judicial candidates. We think that the appointment process provides for a better educated look at the candidates for municipal court judges. Again, we are very much committed to quality judicial officers and best practices in our courts, and we would look forward to the opportunity to working with the judicial branch and AOC on putting together training. Thank you.
Perfect timing. Thanks.
Mr. Chair and committee members, Jim Haggerton, Mayor of the City of Tukwila. Thank you for your time this afternoon. And to start with, quite frankly, I was a little bit amazed at some of the earlier testimony because it's totally different in our city. We're a city of 18,190 people, considerably a small city, but we're a major economic engine for the state of Washington and King County with a lot of retail and commercial. That brings a lot of need for a good judge in a municipal court, and she has a full agenda all week long. She handles her duties professionally, and in addition to the way she handles her court duties, she is modernizing the court in the city of Tukwila, something fantastically, going from a paper-generated system to an electronic system. She's a leader in video arraignment, and I've sat in the back of the room on one or two occasions and watched her, and it's just like the people at the King County Regional Justice Center are in her courtroom, the way that's handled. It cuts down the expenses of travel back and forth, employee costs, and everything. One comment on the election of judges. The question I get when I have a ballot in front of me is, what do you know about these judges? Because usually if there's 2 names on there, we're lucky, usually 1 name for each position. People virtually know nothing of the judges that are on the ballot, and they just check a box. I'd rather Tukwila wasn't the victim of a check box like that. We have an excellent system with the appointed judge, and we would like to keep it that way.
Okay, Ms. Sumner.
I'm Diane Supler. I'm the city administrator with the city of Sumner. Thank you for the opportunity to testify. The city of Sumner is smaller than the city of Tukwila. We're a very small court. We only operate 1 day a week. We don't believe we have enough work for more than 1 day a week. So everything gets compressed into a single day. Having a judge, for us, one of the most important things is they have significant criminal experience because because they're moving through so quickly, they need to be fully trained in understanding the criminal justice system. We had the opportunity about 2 years ago to go through the process of hiring a new appointed judge. And I think in that process, it demonstrated that we did our due diligence and our responsibilities to our community far more so than an elected position. We had 20 applicants. We then had 5 outside, independent, separately individuals review the qualification of the 20 candidates that had applied. We had the then seated judge. We had an attorney in our community. We had a prosecuting attorney outside of our city, not doing business inside of our city, as well as a former mayor and a current council member. At that time, they then gave us the top 5. We then had 2 separate panels that included the court administrator so that she could understand who her next boss might be, as well as the city administrator, the deputy city administrator, and the mayor. Then all of that was then reviewed by our city council, and then the position was affirmed. We have had a long history with our judges. They don't change. We were sad to see the previous one go. In preparation, we did this 2.5 years ago, in preparation for this presentation, because we hear that money is important. It isn't. It's running an effective judicial system. It's just like police officers. When do you stop telling them to go catch the guy down the road? We spend more money operating our court than the revenue comes in. But it wasn't, going back into 2008, we don't look at those numbers until something like for today. So thank you.
Thank you. Questions of any of the 3? Senator Flue.
Well, thank you, Mr. Chair. So I have 2. I guess one is a concern. As you're talking about, how you select judges, it seemed like there was an emphasis on administrative streamlining and rapid, decision making and interview by administrators. And normally, I think when we are focusing on justice, what we're really looking for is, fair trials and appropriate execution of our laws. So I'm not saying that well, but I hope I'm making the contrast. And so that's my concern. My question is, when you talk about there hasn't been an episode of review for misconduct, it seems that that's a little bit off the mark, perhaps, when the allegation is not so much about judicial misconduct as it is about, an ex parte communication influencing the discretion of the judge. How would that surface? I mean, that's not going to show up in a misconduct hearing. That's going to show up in a changed decision, which doesn't necessarily raise any eyebrows at all because it's within discretion of the judge. But it is potentially a real miscarriage of justice.
On the one for us, our first screening process was by professionals outside of administration. It was the then judge, another attorney in practice, as well as a prosecuting attorney, because what they were doing was we wanted the most professionally qualified judge. It wasn't about how much knowledge, because quite frankly, the individual that we ended up appointing had done some pro tem, but was not in fact a judge. And the other piece is, the dollar amount. Our judges only paid $30,000 a year because we only hold court once a week. And so we were, in fact, concerned about how do we best find the most qualified individual for our community.
Okay, thank you. Let's keep this short.
I will. I was trying to refer to the previous panel's discussion about appointed judges having more issues of misconduct than elected judges, and so that was my reference to the Board for Judicial Conduct not responding to, I guess, misconduct on the part of other city officials. We do know that there are, they talked about a couple of different cases that were referenced, and I would just say that usually there are multiple sides to any story, and there's probably more than meets the eye in those cases.
Okay, other questions? Thank you very much. Appreciate your testimony.